A warm welcome to one and all who were present in this live webinar that is conducted by Sri Venkateswara Law Students Association. Previously, we have conducted webinars with legal luminaries who are proficient experts in their own field of law. Our motto is learning about a subject by reading a book or class learning is different from having a different direct interaction with a person who had an eminent practical knowledge in the particular subject or its field gives more impact on a law student. So this webinar's main motto is to give the knowledge that's very useful for the student when he comes out of college and steps into practice. Today, SVLSA is conducting its 12th webinar on the topic titled Fundamentals of Contract Drafting by Bhumesh Varma sir, who is an international corporate lawyer and managing partner of Corp.com Legal. It is an honor to have you, sir, today in the webinar. Looking forward to have your insightful knowledge on the topic. We'll be having 1 hour session of this webinar, and at last, the participants will be allowed to ask questions and interact with the speaker. Now I would like Mansi Vaishist to give an introduction about our today's speaker, Bhumesh Varma sir. Mansi, over to you.
Thank you, sir. A very cheerful good evening, everyone. I am Mansi and I am pursuing BA LLP from Bhagat Pul Singh Mahila Vishwavidyalaya, Sonipat, Haryana. At first, thank you to Mr. Pawan sir, who is the founder of Sri Venkateswara Law Student Association, SVLSA, and organizer. I would like to take the place to welcome our organizer. Welcome, sir. Now, I would like to take the place to welcome our today's chief guest. Welcome, sir. And thank you, sir, for joining us today. And we are eagerly waiting for your webinar, sir. Now, I would like to hand over the mic to K. Pawan Kalyan, sir, to speak few words. Please, sir.
Mansi, you can continue with the speaker's resume. Pawan
Okay.
is not available.
Okay, sir. Thank you, sir, for giving me the golden opportunity to introduce the chief guest of the day. He is none other than Mr. Bhumesh Varma. Bhumesh, sir, is the managing partner of Corp.com Legal, an independent Indian law firm headquartered in New Delhi. Having started his career at Ajay Bhal & Co., now part of AZB and Partners, Bhumesh, sir, went on to work with some of the best law firms in India. He received the coveted Chevening Scholarship by the UK government in 2000. He became partner at some of the leading Indian law firms, including Ketan & Co., Paras Kuhand & Associates, and Link Legal. His initial expertise areas are advising domestic and foreign clients on inbound and outbound mergers and acquisition transactions, private equity, venture capital, foreign investment, joint ventures, technology transfers, corporate structuring, strategic advice, corporate advisory, due diligence, negotiation, domestication for transaction and related legal law fields. Despite Sir's hectic schedule, Bhumesh Sir is passionate about sharing his knowledge and experience with the fraternity. Sir has more than 500 published articles to his clients, including those on IBLJ, Business World, and many more legal and business websites. These articles are very keenly followed and appreciated by the professional students. Bhumesh Sir is regularly invited as a guest faculty by several law and management institutes in and outside of India, online legal education portal for judging moot courts. Sir also conducts workshops and training sessions for students and professionals on contract drafting, negotiation, corporate law skills. Bhumesh Sir has authored 2 books on commercial contracts drafting and edited one on mergers and acquisition, published by Bloomsbury so far, and inspired to write a book every year on different corporate law subjects. Over to you, sir. Thank you.
Thank you so much, Hari Krishna and Mansi, for this kind introduction. So the subject that we have today is fundamentals of contract drafting. All of you must be studying contract law, I guess, most likely in the first year of your law studies itself. Law college, most of the times, is some sections of the Contract Act, commentary on those sections, case laws, and that's it. That is contract law. But when you get out of your college and start practicing, most of the times in corporate legal practice, you're not asked about law. You are asked to draft a contract or review a contract or negotiate a contract. Most of the times, adequate time is not spent on contract drafting skills at the college level. Even if drafting is there as a subject, the study is divided into so many kinds of drafting: pleadings, plaints, notices, so on and so forth. So the time left for contract drafting is very less. Workshops and interactions like this try to bridge this gap between academic knowledge that you attain at your law college and practical skills that are required for you to be a good draftsman. So let us start our discussion. If you would have any questions, you could raise hands and text it. The organizers could intervene in our discussion and ask me, or alternatively, we can take all your questions towards the end of our session so that not to disturb the flow of discussion while we are at it. So first things first, what are the perceptions about contract drafting? I hope my screen is visible to you people. Mansi, could you confirm, please?
Yeah, sir, it's visible.
Very good. Thank you. So what are the perceptions about contract drafting? I would assume as a student or even as a non-law person, layman would assume that what is involved in contract drafting is you get hold of a template, a draft, a precedent from anywhere in the world. You change some names, you change some dates, you change some particulars, and your job is done. You can pass on this draft to your client that this is your contract. This is the general perception about contract drafting. Am I correct, Hari Krishna? Drafting,
Yes, sir.
particularly contract drafting, is assumed to be simplest of legal assignments. However, having studied law and practiced law for 3 decades or more, I can assure you that contract drafting is one of the scariest, one of the riskiest assignment that you can get. So do not take it casually. Do not think or assume it is as easy as it is perceived to be. So here are a couple of perceptions about contract drafting. Whosoever gets to read a contract particularly non-legal people, they think contracts are dull, boring, not called legalese or verbois or legal jargon and so on and so forth. So the idea here being is that contract should be in such a language that only legal professionals should be able to read, understand, and implement it. That seems to have gained currency in the legal profession over the last few decades or centuries, that contracts have to be complicated, otherwise they are no good. So many a times your superiors in the profession, in your company, in your law firm would assume or expect you to churn out drafts which are complicated, which the other party or its lawyers or anyone else is not able to comprehend, understand, implement. What are the reasons behind this kind of thinking? One is history. I'm told that few centuries back, lawyers were paid on per page or per word basis. So there was a commercial interest in making contracts long and complicated so that no one can understand. So you could write as much as you want. So that was the commercial incentive. Two, culture. Because we have inherited this practice, we carry it on. That unless we come across something which is detrimental, we don't feel like changing it. So the culture is being perpetuated. Year after year, firms have their templates, companies have their templates, which they feel are time tested. So why should we change it? So a change occurs only when something goes fundamentally and drastically wrong. So do you want to perpetuate, again, carry forward this legacy of complicated, irrelevant verbois, legalese, jargon, or do you want to change the culture? If your answer is in the latter, you are at the right place. All of you must be law students, but do you have an idea as to what does a lawyer do? Can a participant unmute and say, what is your assumption? What is your understanding about what does a lawyer do? Anyone? Because PPT is running, I cannot see the chat. So you'll have to speak up. And if people don't speak, I don't know whether you are listening to me or not, whether I'm clear or not. Mansi, am I audible?
Yes, sir, you are audible.
Yeah, sir, you are audible.
Yes. So what does a lawyer do? What is the job of a lawyer? Does anyone know the answer? Or does anyone have the idea as to what will you do after you get out of your law college?
Sheikh, you can unmute yourself and answer the question.
Right. Yes. Anyone else?
Yes, sir. Good evening, sir.
Yes.
My assumption or my basic idea is to make aware of the legalities which a common person is not aware of. Being a
Okay.
lawyer, we are well versed with the subject.
Okay.
So, from that perspective, lawyers will be the missing link between the common people and the departments involved.
Sir, your voice is not clear. There is a glitch, I think so.
But there are subtitles. You can read them.
Okay, sir.
These are some of the things that lawyers would do. Now, how do lawyers do all this? All the professions have some tools. All the professionals need some skills or deploy some capital, right? Be it a cobbler, be it a mason, be it a software engineer, be it a shoesmith, be it a blacksmith, be it an ironsmith, be it a carpenter, right? Everyone needs some tools to work with for their craft. What are a lawyer's tools? Any idea? What
So
do lawyers work with?
legal
What do
knowledge,
lawyers work with?
legal knowledge.
Words, isn't it? Lawyer work with words, written words or spoken words. Is there any third way? Lawyer either speaks or writes. So, in order to be good at legal profession, what do you need to do? You need to befriend words. You have to become a wordsmith. You've heard blacksmith, goldsmith, ironsmith, this, that.
Yes, sir.
Lawyer has to be wordsmith, a master of words. You have to play with words throughout your legal life, be it drafting, be it arguing, anything. You cannot do without words in the legal profession, like it or not. Because in law, every word has a different meaning. Some client may come to you and say, I am giving something, give. But what exactly is the client doing by this giving? You have to decipher, you have to understand, you have to contemplate, you have to envisage and put the right term in the contract. What does this give mean? Is it a refund? Is it a donation? Is it a payment? Is it a sale? Is it a lending? Is it a compensation? Is it a contribution? Is it a gift? What is it? And these are some words that came to my mind instantly. These are some of the words with different legal connotation, different legal consequences, implications for the clients. So client will come to you and say, I'm giving money or goods or services and so on. But what actually is the client doing? You have to understand and put the correct term in the contract, because legal consequences, legal relationship, legal implications would be different in each of these cases, right? Another small example, a client may come and say that I'm partnering with this other party for this venture. Client will say partnership. you have to see whether it is actually a partnership, an agency, a distributorship, a franchise, a license, a club, an employment agreement, or what. Whether it is actually a partnership or some other legal relationship that the clients are creating with the other party. For the client, it is a simple partnership. So clients use words very loosely, vaguely, unknowingly. Being a legal professional, as one of you were saying, you possess the knowledge and understanding of legal implications. This is where your value add comes into play. You have to advise the client as to what is the exact nature of your relationship. And these are the legal consequences that will follow. So words, first things first, words are very important. You need to have a good command over language. And you should be able to understand different implications of different words, different legal relationships created by different terms. In law, every word, every punctuation mark is important. So we were discussing about issues with drafting, perceptions. So we will discuss 2 or 3 biggest problems with drafting. Why people think legal drafting is boring and dull and complicated and complex and whatnot. First problem is wordiness. More words than necessary. Every word in your sentence should deserve its place. Every word. Now on, just observe what you are writing, your sentences. Does every word add value to what you are writing? Or are some words useless, superfluous, unnecessary? Simplest examples, reply back. Do you need to say reply back? What does reply mean? You may say repeat again. Do you need to say repeat again? Repeat is sufficient, isn't it? You may have read sometimes free gift. Being law students, you would know gifts are always free. There is no consideration for gifts, isn't it? So the word free is useless in this term, free gift. You say absolutely clear. Clear means clear, right? What does absolutely add to the value of clear? You've seen Sprite ad, clear hai, isn't it? They don't say absolutely clear hai or slightly clear hai. Either it is clear or it is not. So such words most of the times confuse the purpose or dilute the effect. And repetitions at different places in a document can lead to contradictions. You may miss 1 or 2 words here and there at different places, and the meaning would change. There will be an issue of interpretation. What will prevail? Right? And if you are writing too much, it may slow down the reader, confuse the reader, and the reader loses interest. You may have read so many, novels and books which you find boring. You don't feel like reading them all because there are too many words, too many unnecessary details. So use as many words as are required. Wordiness is the biggest problem with legal drafting. That is first issue. Second issue is cut, copy, paste. Blind cut, copy, paste. You get hold of a template from anywhere. Just change the parties' names and dates and few particulars, and you think your job is done. And you pass it on to the client or the other party. That is fundamentally wrong approach. In legal profession, you have to customize every document to suit the requirements of the present transaction. Because the earlier template which you are using may have so many things which are not relevant to your present assignment. A lot of provisions, legal provisions, case laws may have undergone a change after that draft was executed. Lot many things may be missing in that template, which are required for protection of your client's interest. So you are playing with fire if you do not apply your mind to a template that you are using. For example, you may be buying so many garments, ready-made garments these days. Customized tailoring is very rare, right? You go to any big showroom, you buy, shirts, trousers, dresses, so many things. Do all these garments fit you as it is all the times? Particularly say trousers. Does everything you buy fit you instantly? Anybody? You wear all these garments as it is?
No, sir.
No, sir.
Why? Then what do you do?
We purchase new garments as it fits to us.
So when you buy new garments, do you wear them as it is? Or does it require some work?
Yeah, it requires some work if it doesn't fit to us.
So you give it for customization, right? Length of the trousers, you get it customized, right? It's all kacha all most of the times. It's not finished. So you give it to the tailor for appropriate length, right? And some garments may require loosening up or tightening and so on. On some garments, buttons are not finalized before they give it to you. You have a choice and you can ask them to put some particular accompaniments. That is customization. Same happens with contract templates. There may be hundreds and thousands and millions of templates floating around on internet, in books, in your database, in your friend's database, in some law firm's database, and so on. But it is not necessary that the template you are using will fit into your present assignment. You have to customize it to suit the requirements of the particular assignment that you are handling. So be very careful and conscious about this aspect. Do not cut, copy, paste blindly and without application of mind. Third issue is not reading any document completely and jumping to conclusions instantly. Like in a contract, there may be 50 clauses. You read and analyze only 5 to 10 particular clauses which you think are most important in a template. You customize them and pass it on to the client that, okay, the job is done. But that is not the case. A dispute from any contract can arise out of any punctuation mark, any word, any sentence, any paragraph. So you have to pay equal attention to all provisions of a contract. Whether analyzing the one in the draft you are reviewing or whether incorporating some new provisions which you think are missing from this template. So these three things: get rid of wordiness. 2, no blind cut, copy, paste. 3rd, reading and analyzing the entire document. If you get a legal notice, read it entirely. If you have received, some pleadings in a litigation matter that you're handling, read it completely. If it is a contract, read everything completely. Okay, these three things, if you take care, I think 80 to 90% of your drafting issues will be sorted. Now, what are contracts drafted for? Contracts are drafted to pursue some commercial transaction. Contracts are not drafted for your literary pleasure or your literary trip. Whatever you write in a contract, whatever you draft, must be understandable and must be capable of being effected. Like you have curated a transaction through this contract. The people who are in charge of implementing and working on this contract must be able to implement it. So drafting is no good if it is not effective. Good or bad drafts differ in terms of their effectiveness, whether this draft can be effectively carried out or not. That is the benchmark of a good contract. So use, as I said earlier, use less words but effective words. So whatever you draft must be very effective. Let us discuss few aspects as to how can you make your contracts effective. First one is very simple to remember, the KISS principle. Keep it simple. Keep it short and sweet. Whatever you want to remember out of these, keep it super simple. Simplicity is the best sophistication. There is nothing better than simplicity. That should be the benchmark. Whatever you write, whatever you do in life should be simple. That will make things easier for you and the other stakeholders involved in the process. I hope this principle everyone will remember for sure, even if you forget anything else. The KISS principle. Second is misery with words. As we discussed earlier, words are your tools, words are your capital. Treat them as dearly as you treat your money. You won't like to waste your money, would you? So use as less words as possible. Be a miser with words. Do not waste your words. Third principle is condensation. Condense everything that you read, that you hear, that you observe. When you are drafting a contract or reviewing a contract, you may get to hear a lot of things from different people. Your own client, the other party or parties, the other party's lawyers. Sometimes there may be accountants involved. Sometimes there may be merchant bankers involved. Sometimes there may be brokers involved. Sometimes even the government agencies get involved with the commercial contract. So you will have to hear so many things from so many people about their concerns, their expectations, their apprehensions, and so on. So what you have to do is to hear everyone, condense it, put it in as few words as possible in your draft, working to maximize your client's interest. That is the art of condensation. That is the third principle. Fourth principle is understandability. Your drafting should not be like marriage mantras, which are recited usually in a language that no one understands, or medical prescription, which only the chemist or the pharmacist can make out. Your writing should not be like this. In fact, a funny thing here, many professionals assume legal drafting to be an L to L communication, lawyer to lawyer communication, that only lawyers should be able to understand it. Lawyers, judges, arbitrators, regulatory authorities, legally qualified people. Only those should be able to understand it. My line of thinking is that legal drafting should be L2E communication. Lawyers to everyone. Whosoever is reading it, legally qualified or not, should be able to understand, because many of the people who are supposed to implement this contract may not be legally qualified. They may be management professionals, they may be software engineers, they may be doctors, they may be architects. Even they should be able to understand their obligations and consequences of non-compliance. Then only will your contract become effective. So your contracts, another benchmark for being a good, effective contract is understandability. And these are some of the essential parts, components of a good contract. Any of these elements is missing, then you are missing out the big picture. Your contract is incomplete. You need to go back to your draft and complete it. First and foremost is the title should be correct. It should reflect the exact legal nature of the relationship of the parties and or the transaction being carried out under this contract, whether it is a lease, a technology transfer, a principal agent relationship, whatever, either the relationship of the parties or the transaction being carried out. It should clearly reflect that. Thereafter, your focus should be on explaining the subject matter of the contract. What is the exact transaction the parties are carrying out under this contract? Or what is the contractual relationship the parties are getting into? If there are any preconditions for fulfilling or say starting your relationship, like in a lease deed, many of you may be living in paying guest accommodations or apartments. There are preconditions from both sides. The landlord would expect you to pay some deposit, advance rent, cleaning charges, annual charges, maintenance, so on and so forth. Those are preconditions. If you don't pay up, the landlord will not let you enter the property. Similarly, you would expect the property to be cleaned up, to be painted, furnitures and fittings should be in good order. Only then you would like to start paying rent. So preconditions can be from one side or both the sides or all sides. If there are any preconditions, those should be captured in the contract. Most important part, what are the rights and obligations of the parties under the contract? Those should be effectively captured. Rights of one party are the obligations of the other party. Like we have fundamental rights, don't we, under the Constitution? So our fundamental rights are the obligation of the state, that the state has to ensure that we are able to exercise our fundamental rights. Similarly, in a contract, if I enter into a supply agreement with a supplier, I have a right to receive goods. So it is an obligation on the supplier to make these goods available to me at a committed time and place and manner and volume and so on, right? Similarly, I'm supposed to pay up for this supply. That is my obligation, and it is the supplier's right to get payment for the supply. So rights and obligations always go hand in hand. They are not isolated things. They work against each other. Then working framework. How will this contractual relationship work? Like take for example your college tenure, say 3 years or 5 years. Assume 5 years course. You have a working framework, right? There will be classes, there will be exams, there will be midterms, there will be moot courts, there will be vacations, there will be internship breaks and so on. If you pass so many exams, you will be promoted to next class. Otherwise, go back home, right? So that is the working framework. And then there has to be a time frame. Your tenure in college has a fixed time limit, right? You can't be there for the rest of your life. You have to complete your course. Maybe you'll be given a year or two's grace to complete your exams which you have flunked. If you're supposed to receive payment under a contract, do you want a time frame for payment or not? If you get into employment, do you want to receive monthly salary or not? So there can be no contract without a time frame for supply of goods, services, promise, payments, and so on. Then we come to representations and warranties. This again is a very detailed subject which we can take up in an extensive workshop, but broadly these are statements made by parties to convince and comfort each other. Reps and warranties. And sometimes this is the biggest clause in a contract. Then remedies for non-compliance or defaults. What are the parties entitled to if the other party does not fulfill its promises under the contract? What if there are disputes between the parties in a contract? You need to have a good dispute resolution system. And if nothing works, you have a termination clause that works like a divorce. So either you have a time-bound contract, that this contract will terminate after 1 year, 2 years, 5 years, or in addition to that, you provide a termination clause. In what circumstances, situations can parties terminate their relationship? So these are most important, primary, basic, fundamental components of a contract. A contract would be incomplete without these. And what should be features of good contracts? They should be crisp. Crisp in the sense fresh, readable, interesting. If someone starts reading your contract, one should feel like finishing it in one go, not getting bored, keeping it aside and going out for lunch or snacks or tea or sutta. So your contract should read interesting. Clarity. We cannot overemphasize clarity enough. It has to be clear. No place for ambiguity. And concise. Wordiness, as I was saying. Avoid wordiness. Get to the point as soon as possible. Repeating the same thing, beating around the bush, as we call it. Complete. Try to envisage as many situations as possible in your contract. Your contract should be one-stop shop for the reader and the parties. Now, if this happens, this is the recourse, this is the method, this is the time frame. The parties need not go elsewhere, need not go into manuals, need not go into, bare acts or case laws. All the eventualities, consequences, implications, resolution should be there in your contract itself as much as possible. Incorporate most important provisions contemplated between the parties or apprehended between the parties. Okay. The contract is a legally enforceable agreement between the parties, isn't it? That is the very basic definition of a contract, that it has to be legally enforceable. So ensure it complies with everything. Law, rules, regulations, company policies, and so on and so forth. Do not become party to something that is illegal. Then it will not be a contract. Do not lose track of common sense. If you don't understand something, the reasoning, rationale behind any provision, please question the parties as to why is it so. Like if a particular product is sold to all the parties for 10 rupees a piece, and under this contract it is being sold at 1 rupee a piece, doesn't it make common sense? There could be something shady, under the table, illegal, unethical, you never know. So whatever does not make common sense, please question that. Understandable. Whatever you write should be understandable. We keep repeating it. Your contract should look like an original, not a duplicate. It should not appear on the face of it that you have copied this from some good law firm's database or you have captured it from Google. Balancing is a fine art. Your contract should balance the rights and obligations of all the parties as much as possible. Yes, our client is our priority, but do not make it too one-sided that the other party refuses even to negotiate and says, I mean, this is no good. We don't want to discuss with you. Try to keep it as balanced as possible. This will reduce time in negotiation and expedite the execution of a contract. And at the end, check everything from all perspectives. When you think your draft is final from your side, check everything once again. So these are the top 10 criteria from my side for a good, effective contract. The contract has to be crisp, clear, concise, complete, compliant, making common sense, understandable, original, balanced, and everything is checked in time and again. So contracts are similar to storytelling, I keep saying. Assume that you are a storyteller. Your story should be so good that the other party believes it and buys it and goes by your version. Your story should be convincing enough that the other party finds least grounds for objections or negotiation. A couple of slides back, we discussed balancing, right? So your story has to be a balanced story, which takes into account every party's interest. And if you were to imagine yourself as a cook, keep these two dishes away. Do not make a khichdi that is a mishmash of different provisions from different contracts or jalebis going round and round and round and round. Come to the point at the earliest. Okay. How will you learn contract drafting? These are some aspects that you should bear in mind. You should read as much as possible. Broaden your reading. Do not confine it to legal studies only. Read about economy, politics, international relations, sports, movies, everything. You don't know which client will come to you for which industry transaction. So you should have some industry specific knowledge. And believe me, there is no one to teach you contract drafting in law firms or law offices. From day one, you will be expected to start billing. You work and you bill. No one is there to teach you, train you in contract drafting. If you assume that, they will for first 3 months, they will teach me how to draft a contract, that will not happen. From day one, you are supposed to churn out billable work. So learn it during your student days only. Start as early as possible. So reading will broaden your vision. You should know about as many subjects as possible, to the extent possible, proportionately, and try to feel like every party in the transaction. If I am feeling like my client, what is my client's reaction? What is my client's expectation? I draft accordingly. What will be the other party's reaction to this proposal? So I moderate it accordingly. So try to feel like every party and then draft. And nothing substitutes practice. Practice drafting contracts, reviewing contracts as much as possible. So broadly, you should know the gaps between the academic skills that you have acquired in college and the practical skills that are required for you to excel in the profession. Know the gap and bridge it. That is the key to your success in any profession. So in terms of sequence of provisions in a contract, there are broadly 4 parts. First part is the preamble or background part. This goes on from the cover page, title of a contract, description of parties, whereas clauses, and then the agreement clause. The parties agree as under. Second part is operative clauses, the distinct feature of any contract. Third part is boilerplate clauses. These are standard terms and conditions, which are like interchangeable between different contracts. These are more or less standard terms. And fourth part could be some annexures, some maps, some government approval, some articles of association, and so on. So this is the sequence of provisions in a contract. So contracts are not strictly an art, not strictly science, not strictly skill. It's an experiential learning. You keep experiencing, you analyze, you learn, you unlearn, you relearn, and so on. It's a system of constant evolution. There is no perfection ever in this. You always keep improving. There's always a scope for improvement. So you keep learning, you keep improving, you keep getting better. So what next do we have? This is very basic first discussion we have had on this. If you want to learn more on the subject, we conduct workshops, clinics, courses in association with organizations and in association with law schools. You can take reference from my books on the subject. We keep posting articles on contract drafting subject very regularly on LinkedIn and elsewhere. I post daily tips on contract drafting skills. We have a Telegram channel also where you can see all the tips together at one place and the articles on the subject. And last but not the least is practice. Nothing is better than practicing contract drafting because it is an experiential learning. No amount of courses, workshops, lectures can enable you as much as your practice can. This was my survey sometime back on practical training on LinkedIn. 90%, more than 90% of students and professionals say that, more than 25% of time of our law colleges should be spent in practical training. More than 59% say that it should be more than 50%. I don't know if we are any close. Practical skills constitute, I think, less than 10% of our curriculum as of now in law colleges. Please correct me if I'm wrong. So there is a need to emphasize practical training like we have in management, we have in engineering, we have in medical. In legal, we are lacking practical training in law colleges. It is only lectures and exams most of the times. This is the book that I was referring to. If you want to learn the subject in greater detail, you may refer to this book. Any questions?
Any participant
I'll be happy
have
to
any
answer any
questions?
questions.
If any participant have any question, they can unmute themselves and ask the questions.
Yes, Saksham.
Good evening, sir. First of all, thanks for the awesome and intriguing session, sir. I have learned a lot covering the nuances of drafting. So I just face a problem like maybe happened with me as well only. Your slides are not changing. Could you please go with the slide where you have mentioned about the books? I have not referred with that.
You can just put my name on Google or on Amazon. You'll get the link to all my books.
Okay, sir. So
If you spell my name
apart from,
correctly.
yes, sir, yes, sir. Uh, Apart from this, I have a question. Like, sir, as you have mentioned that we are facing a issue in law school, like regarding practical training, and
Right.
as you have mentioned that it's about the experiencing. So, in the current scenario, there are many courses. Like there are a number of organizations those offer contract drafting or pleading or PIL other related projects, workshop and other details. Could you please suggest whom you look that they are the best, some sense that they are doing a good for that we can attend their session, as you have mentioned that you are posting about the same as well on on your Telegram channel.
Well, to start with, maybe you can go through the book that I have referred. That will give you a lot of insights. You could join our Telegram channel. That will give you like 500 plus tips at one place. Our articles on the subject at one place. Then thereafter, if you have time and inclination, you may go for some courses, but be judicious about these courses. I mean, with some amount of experience, I can say even second year students are, putting up these courses on the internet. So you should know which course, which professional is good, experience enough, whom you would like to learn it from. So go for a good organization which is putting up, assembling these courses. So just do not do any course for 200 rupees or 500 rupees and so on. Just don't go by money. Be judicious about the course you are pursuing, because more than the money, it is your time that is being, you know, exploited there. So be judicious about the time that you spend on any such courses.
Thank you, sir, for the great advice. I have some question, some doubts in my mind, like how I can go. Like I'm a new as in law, and how I can judge. Like they have some experience as well. So thank you for the same, sir.
Welcome.
Does anyone have any more questions to ask? You can unmute yourself and you can ask questions if you have any doubts. So I think we can enter. I just want to give a vote of thanks and close up my speech. First of all, thank you for accepting our invitation, sir, to do webinar with us, and mostly explaining most of the things about drafting that we don't know as a law student and we're not aware of. Also, the importance of the problems that we make mostly as a lawyer when we go into practice, like doing the copy pasting, which maybe every time happens mostly, and wordiness. I think it's the most important thing that we as a lawyer, when we step into the practice, should be aware of. Have to know new words that should we use in the drafting and should not do the copy paste, and also reading the document in very clear and clarity is also the most important thing, as you mentioned. Also, the tools that you have explained is very important. And thank you for explaining the essential part of components of drafting and the KISS principle that you have mentioned in the webinar also. Also, I have mentioned the need of industrial awareness that everyone should have. So I have one question, sir. What do you think the part contract drafting will be in the upcoming artificial intelligence?
even with the advent of computers, we have, when computers were introduced, there was an apprehension that people will lose jobs. Has it happened?
Yeah,
In
yeah.
fact,
No,
more people have got employment with computers now. Everyone is working on
Yes.
computer, I guess. So even artificial intelligence will not take away lawyers' jobs. It will create jobs for lawyers. So we should always be well versed with the new technology and new softwares that are coming up, and embrace the technological advances that we are making in our profession. So it will be helpful for the profession, I feel.
I think we can see the option of Grammarly like tools so that we can use in while in drafting, where it helps us to use new words and punctuations while drafting.
Yes,
Thank
exactly.
you very much, sir. With this, thank you very much, sir. And once again, thanks for accepting our invitation in doing this webinar. And we hope we do other webinar in future possible. Thank you, sir.
Thank you so much. I
And
enjoyed
also,
thoroughly interacting with you.
thank you, sir. And also, I would like to thank Pawan and Mansi for making this webinar happen. Thank you, sir.
Thank you. Bye-bye.
Welcome.
Best of
Thank
luck,
you.
everyone.
Thank you, sir.
Sir, could you please share the Telegram name or the details which sir are referring?
Yeah, I will do that.
Do that.
Actually, sir, shared your link.
Sir, I think I am unable to look into the chat.
Yeah, that's what I'm also from the start trying to give more options to you guys. And there has been a technical glitch. I'm not able to find the options because we had Microsoft Teams new platform.
Yes.
I
Sir,
mean,
is this okay if you can share the links in WhatsApp group?
yeah, sure, I will do that. I will share every link that has referred by Sir, and I will give forward those links to the group WhatsApp.
Okay. Sir, do we have the slides which sir are referring?
Yeah, I will
Maybe I
ask him to
think
share.
because during the session I have tried to unmute myself. From my point, the slides are not changing one after the
Sorry,
other.
sir.
But sir is
I wanted.
discussing clearly, so that's why
Yes, sorry
there's
for
no
that.
issue at that time.
Sorry for
No, no,
that,
sir.
everyone.
No, sir. It's not. It's not issue.
Fine, we can unmute it all at a time. Rahul, if you
Okay.
want to say anything, you can say. You can
Thank you, sir.
unmute
Uh,
Thank you for
yourself.
yes,
organizing such an amazing session.
Thank you,
yes, sir.
thank you.
Sir, hi, I'm Rahul. I just wanted to ask that can I be added in that WhatsApp group regarding which you are
Yeah,
referring right
you
now?
can just tell me your mobile number.
Yeah, please note down.
Yeah, sure.
99700
79700
49269.
4926. Sure, Rahul,
And
I will
sir,
add you.
yes, thank you, sir.
Yeah,
And tell me the name of that Telegram channel. Is it? It will be great help.
just a minute. It is daily tips on contract drafting.
Uh, can you
Rahul, did
please
you
say it
get
again,
it?
sir?
Yeah, it's a daily tips on contract drafting.
Daily tips.
Yeah, daily tips on contract drafting. You
Okay,
can
sir.
join
Yeah.
this Telegram group and get tips that is forwarded by Sir.
Okay, okay, sir. Thank you very much.
Thank you. Guys, a platform, does anyone is facing any problems in this platform, Microsoft Teams? Hello, is my voice is audible?
Yes, sir. You are saying something?
Yeah, does anyone is facing any problem in this Microsoft Teams platform while webinar is going on?
Sir,
No issues.
So, okay. Because I heard a few people saying that they're not able to unmute themselves when sir asking questions. So that's why I want to make sure that you guys are facing any problems.